Minister, at the outset, I want to thank you for engaging in this in your new brief, and to be fair, Minister Troy before you as well. And as you know, both myself and Deputy O'Reilly are members of the Enterprise Committee, and this subject has come up in PLS in terms of Enterprise Committee work as well. And I think insurance reform has it's been a long-running saga in Ireland, to say the least of it. And as I said to you, I think I said to the Taoiseach the last day in committee, I seem to remember the Fine Gael minister in Wexford who came and went trying to deliver insurance reform, and it wasn't possible. But we have implemented PIA back in 2003, and to a lot of fanfare, and I think people were expecting pretty significant things from that in terms of reform. And what was it supposed to do? Essentially, it was to try and streamline the process and to try and reduce the costs, these elevated costs, both in the award side and in the costs of claims and the legal fees. Oh, I beg your pardon. Beg your pardon, going shit. In terms of the legal fees. And it looked for a while that was going to have some success, but over a period of time, unfortunately, a march came along, and more, and as you're aware, the majority of cases are not going through PIA. They're basically going towards the direction of the courts, or they're being settled out of courts. And we then had, the appointment of a judicial review in council to try and arrive at a better foundation in terms of the claims outlook, to try and get a book of quantum that more reflected a fair book of quantum, particularly in line that most of our insurance is underwritten from the UK and outside. And, our book of quantum was completely out of whack with theirs. So all of this was done as part of the ongoing PIAB legislation, and we now have a book of quantum that is agreed, and we have judicial guidelines around that, which we would hope to see, and it's still not happening, by the way, but we hope to see the Law Society taking stronger notice of those. But I suppose where we've arrived at, and with respect to the amendment that I have proposed to you, Minister, it was, I suppose, quite clearly prefaced on the basis of having a review procedure, a recurring review procedure, to ensure that all facets of the PIAB, PIRB legislation were going to work as designed, and also that we could track and see that we were making progress on the areas that we need to make progress on. And I suppose what I had asked for, and I was looking at the legal services legislation of 2015, and there was a review procedure built in there, and essentially what it asked ministers that you would do a review within 12 and no later than 18 months of the initial enactment, and then further on that you'd provide a periodic review and report to the houses of the Oireachtas every 3 years further to that. And basically from there, any recommendations resulting could be brought in amendments to try and change the founding legislation. That was the reason. And as I read it from your amendment proposed, I don't see how we can get back at the founding legislation. Your amendment speaks to only this latest draft of legislation that we're talking about. I think that's a misstep, personally. And I just wonder, and I know, Minister, and I take your bona fides and your word that where you've said to me, that we leave no stone unturned, and we'll make sure that when we go back, we look at this in detail. But I would prefer to see something in the legislation that speaks to that. Now, I accept that you have agreed to a review, and I'm sure that probably wasn't easy in terms of where the department wished to be. Maybe it's very onerous on the department, and you have committed to one. I would prefer to have seen, and maybe we can still get something done if you're prepared to accept some periodic review procedure. I think it's needed, Minister, first and foremost, for transparency. I think the other thing that I was interested to listening to a debate recently on radio about insurance, and we have a very difficult insurance market here at the moment, as well you're aware. We have a significant number of underwriters who have left the market, and we have players who have left the market. And in order to try and entice new competition into the sector, which is what we all wish to see, we must have better transparency in terms of, I suppose, where the payout and claims situation is going to land. And at this moment in time, you're presently working on, I understand, the duty of care, the occupier's liability insurance. And liability insurance, Minister, as you're aware, has risen nearly 50% for a lot of businesses this year. We've had businesses that have had no claims, and they've suddenly seen an increase in their insurance of 50%. And the whole problem here is that, we basically have largely a lot of latent claims still lying around. But there isn't security, I don't believe, in the insurance sphere. And we have had a reduction in motor insurance, which is to be welcomed, but at the same time we've had a dramatic rise in liability insurance. And the difficulty again that I see is when you bring in the duty of care legislation, we'll probably be bound up in this process again, where we won't have a review process potentially for that, beyond maybe this one look back. So, Minister, I would really ask you, and maybe you might, in your response, highlight to me what you feel more that you can give, or what I don't want to say guarantees because that's not fair, but I think in terms of the Minister's office, and maybe you won't occupy that chair, somebody else will, but how can we bind the department to a really meaningful review of this legislation once enacted, to try and give us the look back, to try and understand that the legislation is working as required. And clearly what that is going to mean, that more and more cases are going to go through PIAB. And we know that if they go through PIAB or whether they go through the courts, the actual amounts of rewards are nearly the same, but the legal fees are dramatically different. I just looked at a table there earlier today where cases in PIAB were being settled for €1,018 and they were costing €23,000 through the courts in terms of the legal fees aspect. And that to me is just, that makes no sense. And this is damaging, I suppose, credibility. It's absolutely hurting business, it's absolutely hurting policyholders. And I think we have to get to a point of insurance reform that people can believe in. And I would, as I say, and I'm really, I know we've spoken earlier today, and I think you've given me your position, and I do accept your position is difficult, but I would ask you maybe in a couple of minutes if you could highlight to myself and anybody else who's watching, what kind of guarantees can you give that we're going to have a robust process in terms of this review? And if this review brings up something, Minister, what is the legislative procedure to bring further amendments to the legislation? How do you see that happening? Maybe if you'd highlight that, that would be a help, if you please. Go on.
Thank both deputies, and I appreciate Deputy Shanahan's amendment, and I appreciate both deputies' remarks in the way that we worked on this. Deputy Shanahan's amendment is based, as he said, on the provisions contained within the Legal Services Regulation Act 2015. The Personal Injuries Assessment Board was established in 2004 and has been making assessments for more than 18 years. The legislation that established it in 2004 has been reviewed several times since its original enactment, and we've had amending legislation twice since I entered this House in 2007 and most recently in 2019. So it hasn't been a static piece of legislation. It has been reviewed even without a formal review clause. The current bill that we have here this evening is a result of a thorough examination of the legislation and the operation of the board. It included extensive engagement with stakeholders, and while I wasn't Minister in place at the time, Deputy Troy was, the PLS was particularly helpful. And that has led us down to introducing this new function for the board through mediation. And I agree, and we all agree, that a review of these new powers of mediation is appropriate. I'm concerned that a statutory requirement for a constant rolling review of the legislation, which is what's envisaged in Deputy Shanahan's amendment, will result in a certain element of paralysis within the system, that there's constant reviews, that people are constantly preparing for review or responding to a review. And in the meantime, what I want to see is mediation going to work. And I want mediation to be given the space to work. And I want PIAB, or PIRB as they would have been known, to be given the time and the space to make mediation work, so that we all hope that mediation will result in a much better outcome for those going to it. And I really want the board to be given that thing to do. Secondly, the statutory provisions regarding the Legal Services Regulatory Authority require the body to actually review itself, so that it can review itself, review the operation of its own act, and then that it makes the recommendations to the Minister, having reviewed itself. I actually think the amendment that I'm putting forward on behalf of the government, that the Minister of the day will undertake the review rather than PIRB reviewing itself. And the Minister of the day is answerable to the House. I don't know who will be here, but they are answerable to the House more so than the PIRB will be.
You get one more chance to go in as the proposer. Yeah, Dr. Shanahan.
Good last comment, Minister, yeah, look, as I say, I accept your bona fides in terms of the difficulties that you envisage and the reasons that you've put out why you feel that a periodic review is difficult. I think we probably differ on that, but I accept that that's your position. In terms of the commitment that you've given within the amendment to engage with stakeholders, is there something that could be written within that to ensure that the Minister of the Day and the Department would engage with, I suppose, umbrella groups or representative groups of stakeholders? Because I just worry about who is actually going to be speaking to the policyholders here. And I think it's very important, if we're talking about insurance reform, we're talking about trying to reduce costs. And there's no point in talking to other people around the process if we're not talking to those who are paying the actual costs and the bills and who are supporting the activity. So I suppose that's the first thing. The second thing, as you say, that this review that you propose will be undertaken by the Minister of the Day. And OK, I can see how that would probably make sense. The question is, will it be done through an external appointed body? Would you think the plan would be to appoint some external review process, or will it be just done in-house as a report that the Minister would present to the House? And again, there's obvious difficulties with that. And I think that what you've said is we don't want to go back and second-guess legislation or reform. I think that's exactly what we should be doing, to be quite frank with you. I think there's a lot of legislation passed in this House that we should have some type of a look-back facility for it. And I know you say, look, it's possible to bring people to bring a bill or bring a private motion or all that. It would be far easier if it was enacted, if it was set within the enactment of the legislation, that process was there. But as I say, look, Minister, I've heard you and I've spoken to you a number of times, and I thank you again for the engagement. And I think it has been positive, but I think the proof is going to be in the pudding in terms of this, and you've committed to a review. I believe it cannot be comprehensive enough and it cannot be wide-ranging enough, and I would like to see recommendations resulting from it as well that might actually make their way back into the House in the future.
It would work, and that perhaps there might be some element of that, maybe as part of the Shanahan debate, that could be recorded as well, that would give people comfort that at the very least there's a halfway house between the very rigorous review proposed by Deputy Shanahan and the review proposed by the Minister. I'm not suggesting it's not rigorous, but that there would be some kind of halfway house there that maybe that could be discussed between now and when this makes its way to the Shanahan. I think we're all agreed this should go through. People are waiting on it. We want to see it. It's progressive, etc. So perhaps there might be a bit of opportunity there. Thanks.
We, the amendment is very clear. The ministerial amendment is clear that the Minister should consult with the board and other such persons as the Minister considers appropriate. It's deliberately not prescriptive, because there could be relevant persons in a couple of years' time that may not exist now, but it does put a requirement on the Minister to consult and to consult people in this space. And I think there's one certainty: the officials, or their successors, will be there when we may not, and they've shown huge consultation, a huge spirit of cooperation in trying to make this work, and I know that will continue within the department. I'd also say that my reading of Deputy Shanahan's amendment is that it's a rolling review. It's not periodic, and that speaks to my concern, Deputy, or in particular, about that it will be constantly under review, and that we won't get the space to actually get the function underway and get the function up and running. And my review is targeted at the mediation side of things, because, as I said, since 2004 we've had two separate pieces of legislation, in 07 and in 19, updating the whole thing. This will be the third piece of PIAB/PIRB related legislation. So I think we haven't left it there. We are watching it. We're not throwing it out there and going away. It'll be under constant scrutiny. And the review process, as I've laid out in the government amendment, lays out that there will be consultation and that it has to be done within a given time period.
Clarify, Deputy, this amendment I'm going to put to the floor now. That means your amendment then can't be put if the amendment is... So we'll come to it in due course, but just a clarification. So at this point, I'm going to put the amendment. So the amendment is being pressed by the Minister. So in the is that agreed, that the amendment be made? Agreed. Garmil. So amendment number 2 is agreed, and we'll move on to amendment number 3. It cannot be moved because, well, number 1 has been already discussed, but 2, it's an alternative. So we're moving on now to the final amendment. In the name of the Minister.
Mark Glasgow, I thank both deputies for their engagement on the last amendment. The third and final amendment is a technical amendment relating to commencement matters for the provisions of the bill. The amendment provides that the new mediation function may be commenced separately for different classes of claim. This models how the original Act was commenced in 2004. The second stage debate stressed the importance of a properly operated mediation function. Providing that mediation may be commenced in a staggered manner will allow the Board to manage the introduction of mediation in a careful and considered way. Providing the Board with additional functions to increase the number of claims settled through its process will increase the number of claims that are settled faster and, as Deputy Shannon referred to earlier, at less cost than other settlement channels. This, in turn, should have a knock-on effect on the cost of insurance, and Laskin Curler will speak to that at the end of the process. And again, I'd like to thank the deputies for their engagement to date.
No. You propose, so the amendment has been pressed. Is it agreed that the amendment be made? That's the end of the amendment. So we're moving on. Lana Majorai Hig an Cuigo came. We now proceed to the fifth stage. I'm asking the Minister to move that the bill do now pass.
I move.
Carmel Margaret, if anybody wants to speak at this point. Yep. Minister? Yeah.
Can I just say a few remarks, Laskin Curler, with your permission? I feel rather like a rugby player who got the ball just before the try line and threw it over the try line. And I do want to acknowledge the huge work that Deputy Robert Troy has put into this legislation. And, you know, I know that he engaged in a lot of consultation previous to this. And I'd too like to thank Deputy O'Reilly and Shanahan, who have been particularly engaged in this, and the committee, and Senator Mullen as we proceed to the Senate. But I particularly want to thank the officials involved that are here with us, Shanahan, and the team in the department who are continuing to put extraordinary work into this. And I wish this function every success. I think we all have a stake in it, that it is successful, and I want to wish the team at PIAB/PIRB every success. But we are doing a lot of heavy lifting in this House in relation to insurance, across party, working collectively, but also at government level. And I think that the work that we are doing should be resulting not just in reduced motor premiums, but in reduced premiums on employers and on public liability. And I think a message needs to go from this House this evening to the insurance industry. We're doing heavy lifting for you. It is time you pass on the benefit to your clients, to your consumers, and let them be absolutely assured that we continue to sit on them until they pass on the benefits of this legislation to their claimants.